So, welcome to the Governors for Schools first webinar under the new methodology. We're talking about GDPR this morning, and welcome to all those who are joining us, wherever you're actually joining us from. And this is your session this morning, so please feel free to use the question facility at any time. I will do my level best to be able to answer that for you. My name is Steve Barker. Some of you may have seen me before at some of the live sessions that we've done. I'm here supporting Governors for Schools this morning from Better Governor. bettergovernor.co.uk is an online service for governors, and we provide a lot of support for governors in something like 138 different local authorities in the UK now. You can see my bio slide there. It just tells you a little bit about me and hopefully why I'm sitting in front of you this morning. But I won't actually spend any time going through that. You can read that at your leisure. Let's get on to the main business of the session. So what I want to try and do today in terms of what I'd like to cover in the next 45 minutes or so is certainly clarify the understanding of the General Data Protection Regulation, or GDPR as we're all referring to it, and how that impacts on the education system. What I'd like to also try and do is ensure that whether you're a governor to maintain school or a governor actually in a local governing body or a multi-academy trust or standalone trust level, you know what your school or group of schools are actually doing about GDPR at the moment, and perhaps if you don't, it will spur you on to go back into school and ask one or two questions. Because ultimately the main aim of this session, of course, is to bring to the attention of all governors that GDPR is an issue of compliance, and as with all things to do with compliance from a governance perspective, our role is to ensure that our schools are complying with this new duty when it comes into place. It's not for us to do as governors, but it is for us to seek that assurance from our schools, from our trusts, that we are compliant in all aspects of the duty. So as I say, any questions as we're going through, please either raise your hand or type them into the dashboard, and I will try and address them as we go through the session. So key question that we're actually addressing this morning is, as I said, are schools ready? Are schools doing what they need to be doing at the moment? Have they done some of the main steps that need to be undertaken in order to be ready to go on that key date, which I'm sure everybody is aware of, is May 25th this year? And as far as GDPR is concerned, I was talking to some governors a few weeks ago, and I think it's very important to recognise from a school perspective that GDPR has not been created as a sledgehammer to go after schools with. It really hasn't. And the ICO, Information Commissioner's Office in this country, they are responsible for all aspects of data protection. They are very keen to say at every opportunity, schools are not the target here. GDPR obviously applies to schools, but it's actually been created to tackle some of the bigger issues in our society and the world generally right now about how secure personal data that is actually handled by organizations of all sizes is actually being treated. And obviously the big issue of the moment is the Facebook and Cambridge Analytica issue, and you can see one or a couple of the pics and logos on my slide there in front of you now. All of the others that are on this slide again have had similarly large and rather eye-watering sums of money involved in terms of fines or speculative fines at the moment, but they are all significant breaches. I put that little news clip down at the bottom right of the slide there just to actually point out that schools generally are pretty good. I'm sure you're all aware, or hopefully you're aware, there's roughly 22,500 schools in England. Only 66 breaches were reported to the Information Commissioner's Office in 2015. That is a tiny, tiny percentage. And the message from the Information Commissioner's Office is a very serious one, but I think actually quite a heartening one for us as governors. And that's that schools generally, if they're compliant with existing legislation, that's a really good start, and therefore GDPR is going to be an evolution rather than a revolution for them. There are some changes, and we're going to come on to those changes in just a few moments, but schools generally are responsible for holding quite a lot of data, a lot of personal data, there's no doubt about that at all, but most schools are already taking very reasonable steps in the way in which they gather that data, they use that data, they protect it. And we're going to talk about some of the key issues as we go forward. I thought it might be helpful just to look at some of the key terms. Now, this isn't everything you ever needed to know about the GDPR at all, but these are the key terms that I believe are relevant to us as governors and trustees in schools and multi-academy trusts, standalone trusts, here and now in April 2018. One of the key changes, and therefore, the key term that we have to be aware of, is that schools themselves are covered by GDPR, and we'll come back to that in a few moments. And most schools now, if not all schools, will be data controllers. And this is significant. If you're the data controller, that means that you are the person or the body that is responsible for the security of that data. And GDPR really is all about security. It's about ensuring that data is handled in a secure way. So the school becomes the controller. The other key term about how we use data is actually the processor, and that's the body or the individual who is actually using that data, doing something with it. And for the most part, schools will be both controller and processor for a lot of that data. One of the things we have to think about is if schools are collecting data and then sharing it with somebody else, and of course that could be pupil records at transition times, etc., then of course they may not be the processor, but they still retain responsibility and therefore liability and accountability for that data because they are the controller of it, they collected it in the first place. The word breach I've put on there not because I think it's going to be a huge issue for schools, but certainly it's one of the headline generators at this point in time. Lots of people are talking about fines up to 4% of global turnover, etc. Now 4% of the school budget is a significant amount of money, of course, but as I said, GDPR is not about going out to get schools and to implement large fines against schools. And the Information Commissioner herself has actually made it very clear on a number of occasions that the ICO, the Information Commissioner's office, want to work with schools. So if a school does have a breach, rather than immediately go in and fine, the ICO will be looking to work with that school or group of schools. And I see we've got a question has just come in now from Kevin. In a multi-academy trust, is the school still the controller or is it the MAT? That's a really good question, Kevin. It is actually the MAT because, of course, the MAT is the legal entity. It is the multi-academy trust that has the funding agreement, the master funding agreement with the Department for Education. So therefore, it is the MAT. But of course, there may be data protection officers in individual schools, and local governor arrangements in local schools still make it a responsibility, of course, that we can't be negligent in the way that data is treated. So that is something that's delegated down. But no, in answer to the question, the MAT would be the controller. Compliance clearly is a word that is fairly common to us in governance. There are lots of statutory regulations, lots of education acts, etc., and elements of those require compliance from us. And I think it's important, and the reason I put this on here is that compliance is something that we do as governors. And actually, GDPR, yes, it's very much a hot topic of the moment, but as we go forward, this becomes just another aspect of the school's compliance, which governing bodies, trust boards are responsible for, but we treat it the same as all other aspects of compliance. And I really don't believe that this should become a major item for all schools on an ongoing basis. We're just in that learning curve phase at the moment, and I think the moment we actually get this embedded as part of our standard practice, that's exactly what it becomes. I've got consent on there. Lots of people are talking about GDPR in terms of you need to get consent, you need to get consent from parents, you need to get consent from staff. Consent is only one of the legal bases for actually getting personal data into school, and it is incumbent upon us as governors to ensure that our schools are using the right legal basis. So when we talk about consent, and we'll talk about all the legal basis in just a few moments, if consent is the most appropriate, and the ICO is saying you have to be really careful because in a lot of instances in schools, consent isn't appropriate. So I was talking to just as a very quick example at this point, talking to a head teacher in a school on Monday this week, And this head teacher told me that they'd already written out to all the staff asking for their consent to keep hold of their bank details. Now, that's a very good example of something that actually isn't requiring consent. One of the other bases is contractual, and of course the school has a contract with every member of staff, and in order to fulfill that contract from the school side, one thing they have to do is pay the staff, of course, and in order to pay the staff you need their bank details to enable you to do that. So therefore consent is not appropriate as a basis for legally having that data. It is contractual. So those are the sorts of things. We'll go through them in a little bit more detail later, but those are the sort of things that we need to be thinking about. So there is a question there from Nilesh: what level of consent is required for schools? Nilesh, hold that thought. We will come back to that. But as I say, consent rarely will apply. It will apply, and we'll give you some examples a little bit later, but rarely will it apply. Most of the things that schools do, there are other reasons more compelling that give them the legal basis for holding, collecting, and processing the data. And DPO there is probably one of the most contentious ones for school. That stands for Data Protection Officer. Every school must have one, but we'll come back to that a little bit later if we may. Okay, at this stage, we'll just want to conduct a short poll with you. Hopefully, what you will see on your screen in just a moment is a poll which actually is asking you, have you talked about this at governing body level at this point in time? Hopefully, the poll should be in front of you now. You can hopefully should be able to see the question. It says, has your governing body or trust board had an agenda item or a discussion on GDPR and how prepared about how prepared your school is? And you get the possibility there to answer yes, no, or don't know. And I can see that people are already voting. That's great. We're up to nearly 80% of people at the moment, so you've got a few more seconds if you don't mind. If you wish to vote, vote now, because I'm going to close the poll any time now. Okay, we seem to have got to a little bit of a standstill there, so I'm closing the poll right at this moment. And I can put the results of that poll up. It's quite interesting. Nice to see that 70% of you in your governing bodies and trust boards have already had a discussion. That's good, that's positive. 8% emphatically no, you haven't. That's a bit of a worry, and I think one of the key actions I would actually suggest that you go away and follow up on is to actually ask, when's this going to happen? It was the 25th yesterday, I believe, so it's only a month away now to the 25th of May. Similarly, the 23% that don't know, good idea to go away and find out, I would suggest. I'm guessing that the new term is upon us now. We've got meetings coming up. Have a quick word with either the clerk or the chair. Is it on the agenda? If it's not, it really should be. So thank you very much for participating in that poll. I'll just take those results down now. Those results will be available after, so if you want to find a copy of those, you will see that on the recording as well. Sorry, screen freeze there. Okay, I mentioned earlier about GDPR applying to schools. Lots of people say, well, why does it? I mean, the reason it applies is because schools are categorized for the purpose of GDPR as public authorities, and public authorities, no matter what their size, are compelled legally to actually be covered by this. But as I put that little note at the bottom there, schools and trusts are already meeting the requirements of current data protection legislation, then GDPR is just perhaps a slight enhancement and a few extra things to do from that, but it's a really good starting point. Governors have asked me in meetings in the last couple of weeks or so, well, as I'm a small school, I've been told it doesn't apply to me because we don't employ 250 people. That's irrelevant, I'm afraid. The issue is all schools, for the purposes of GDPR, are classified by the Information Commissioner's Office as public authorities. So every school must be part of this process of actually moving towards compliance. And as we've already said, if you're a multi-academy trust, then the trust itself is responsible for that. I thought I'd come back now and just talk a little bit about personal data. The whole of GDPR is about protecting personal data, as we said before, and it's important to understand what we mean by personal data. Personal data can be anything that ties us to an event, ties us to anything that might hint at or allude to any kind of means of identification. And the definition has been broadened a little bit now, because actually it now includes online identifiers. So your ISP, for example, every time you go shopping online in John Lewis or Amazon, etc., it's not coincidence that next time you go online, you'll probably see a photograph of an item of clothing or a pair of shoes or a computer or whatever it is you looked at. They are tracking your data. They know what you looked at, and they will come back to you with lots of offers. They're able to do that, but again, that is personal data, and that has to be handled securely, sensitively, and sometimes with your permission. So you will possibly be aware, I'm getting them on a regular basis. I had one this morning from the Automobile Association, but I've had privacy notices from everybody from Microsoft to the AA to my car insurance company, and lots of online shopping outlets that I use as well. So I'm sure many of you will have seen that too. And just be aware that personal data, of course, it's our names, it's any kind of identification number. So national insurance numbers, if you have a username on the school portal, that would qualify. Anything that identifies location, including online, as we've said, genetic data, and then any other data. So again, this is particularly relevant for schools. There is a category called special data, and this is data which is probably regarded, well, not probably, is definitely regarded as slightly more sensitive, or could be considerably more sensitive. So this would be data about physical appearance, about physical health or mental health, economic, social and cultural data, and any other characteristics that we may have provided. So if you think about the equality data that we provide from time to time, so anything on ethnicity, race, on creed, on sexual orientation, all of that is identification data, but that actually falls under that category of special data. So if you think about it from schools, lots of our schools would have medical information about pupils, they may have medical information about members of staff. That falls under that special category data, and there are additional rules, additional safeguards that relate to that. And as far as personal data is concerned, as far as schools are concerned, rather, I should say, from a personal data perspective, there are 4 areas. Now, you might in your school or in your trust be able to identify others as well, but for the most part, I think this will actually work. And I'm putting this up because one of the things that we need to think about at the moment is, have we actually seen our schools complete an audit of all of the data that we collect, that we hold, that we process, that we store, and the security that relates to that? And a good start point for me is to ensure that the school is thinking about these 4 key stakeholder groups here. The staff that we employ in the school, and those that we don't employ but actually are still working there. So the volunteers, they're still members of staff, and we will possibly have a lot of their personal data. We might have details of disclosure and borrowing scheme. We might have names, addresses, telephone numbers. All of that is personal data and needs to be logged in the audit. Pupils, of course, is everything from the personal identification data to information about, as I say, their health, which falls under that special banner, but also all of the academic data, behaviour data, where relevant, etc. Parents, again, contact details and anything else we might have. And of course, as governors ourselves, a lot of our data is actually out there in the public domain, but it's being collected by schools. Now, important to recognise as governors, yes, there is personal data. We agree as governors to share data with each other in terms of emails and other contact details from time to time. And that is personal data, and we do have a say in how that is handled. So it's worth thinking about, have you got a privacy notice for governance in the school or the MAT? But as governors, of course, we are holders of public office, and minutes of governing body meetings are a permanent record. The law says they are a permanent record. So even if you cease to be a governor or a trustee, you are in that particular situation not able to say, I want all of my details removed from every single document. You can say, I don't want my name on the website anymore, and once the legal requirement for that has actually gone, your name can be taken from the school's website, but your name will never be removed from those minutes because they are a permanent record, and it's just worth making that distinction. So some of the key changes under GDPR do relate, as I say, to this idea that we have to have a document, an evidence trail now that gives us all of the backup to say how we're collecting data, what data we're collecting, what we're doing with it, how we're storing it, how security is guaranteed, etc. And that data, sorry, that information, I should say, there's too many datas in that sentence, apologies. That information about the data, that needs to be retained by data controllers in schools. Sorry, by data controllers, and that will be in the school, of course. And that's worth thinking about, because again, that's an issue of compliance. So again, governing bodies, trust boards will be seeking assurance that that's happening on an ongoing basis. I've touched on privacy notices already, and we'll come back to those in a few moments. There aren't much tighter roles on consent, and we will say something about that in a few moments. But again, consent is not the only basis, and it is probably not the one that we will see used most in schools. And as I say, we've got considerations with regard to data protection officers as well. And my next few slides relate to these 4 bullet points. So on documentation, as I say, the audit map I mentioned earlier already, absolutely vital. And this is something I would suggest, yeah, we're getting into a little bit operational territory here, but I think it's quite sensible for governors, as part of the assurance seeking, to ask to see at least part of that data map. So what level of detail does it go into? And it could be that governors can actually add to that, because we need to ensure, for example, as I mentioned a few moments ago, that governor information, governor personal data is included on that. The idea is, not only is it a way of saying, okay, this is a list of all the data that we've got, but it does map out what happens to that data. And that's what we mean by data flow there. It maps out, this is the data we collect, this is how we collect it, this is how it's stored, but of course, most importantly, this is how it's used, or how we process it. Because that word process, you can just say, every time you hear that data process, that means you're using the data, you're doing something with it. And we also have to keep a record of the lawful basis on which that's used, and as I say, I will actually come back to that shortly, similarly with consent as well. And lawful basis, as I say, this is crucial, and this is where I think quite a few people have actually got themselves slightly confused about what the legal basis might be. Consent, although it comes under comes as the first bullet point here as one of the bases, from a school perspective, is one of the ones that we will probably be we will see used least. An individual has to give consent where consent is appropriate. And a good example of that, some of your schools, some of your trusts, for example, will say to parents, we want to keep in regular contact with you. We have a school SMS text message alert system called Parent Mail. Can we have your permission to do that? And permission means consent. So if somebody signs on to that, you would get them to say, yes, they give you your consent to use that. But that's only for that reason of contacting you on things like school closures or anything else that's happening. It does not provide the basis for requiring every single parent to give you their contact details, which you would use in an emergency, because that is a legal responsibility of the school. So if you're following up on attendance issues, for example, the school has a statutory duty to follow up on attendance. Lots of schools will be engaged in doing first day calling if a child is absent from school, and you are perfectly at liberty to retain information such as email, telephone numbers, etc., to contact parents to chase up if a child is not in school. It's part of your safeguarding duty apart from anything else. So you wouldn't need consent in that issue. Contract I did mention earlier. A good example of that is staff contracts, and you need bank details in order to fulfill that contract. I often give the example with people that say it's Better Governor is a service that it's free to access for an awful lot of people, but we do offer a subscription to Better Governor that allows access to an awful lot of the online technological services that we provide, such as chat rooms, forums, we do webinars, etc. from time to time. Now, in order for us to deliver those, we need to contact you to tell you when they're happening. So again, there is a contract there, so we are not seeking your permission. You've entered into a contract. The only way we could actually deliver on that contract is by using your contact details to communicate. Legal obligation is the one area where most schools will see that as the legal basis for processing data. And of course, legal obligation is the law or statutory regulation is telling me as a school, as the public authority, that actually this is my duty. I'm a controller. I must collect this information. I must process this information. Good example there is the school census. That includes information like pupil postcodes, dates of birth, various other information that's actually been given by parents in terms of ethnicity, etc., might be on there as well. And so you've there got a legal basis for collecting not just personal data, but sometimes special categories of data as well. And of course, an awful lot of that information will run over all of those areas. So parental details, governor details that have to be put on the website that we used to call EduBase, it's now called GIAS, getting information about schools. That's a good example of data being collected, being processed, because there is a legal obligation to do so. And anything, of course, in terms of pupil progress data, pupil performance data, would also similarly fall under that, that particular legal basis. The next one of the bases I'm actually going to talk about is the vital interest. Vital interest is all about, it is protecting life or health, welfare, etc. And a good example, I think, of this in schools is you don't need anybody's permission to have a photograph of a child or a young person who is an anaphylactic, who's got severe food allergies, on the wall, appropriately discreetly, of course, in the servery or the dining room, so that those staff who are responsible know how to identify those children who may be vulnerable. Most schools now don't put nuts in the menu, but you might have a lactose intolerant child or a child who's got other food intolerances where it could be life-threatening. That's a very good example of saying, well, a photograph, because photograph is personal data, it is in the vital interest of that individual, the school does that, and you do not need consent. That shouldn't be confused, of course, with consent to go on school trips and consent to actually, parental consent, that is, for children to go on school trips, and consent for photographs perhaps to go onto the school website. But again, you have to think about the use. You don't have consent for something which actually is of vital interest. Public task isn't something that we will see much within schools. Public task really is similar to under the old Data Protection Act, the 1998 Act, there was something called processing functions of a public nature. And the reality is there has to be a clear basis in law for this, but this would be more to do with local authorities, county councils, borough councils, etc., and some of the things that they would be doing with the likes of the electoral register. So this is one that's highly unlikely to come into school. And similarly, legitimate interest, although with multi-academy trust, legitimate interest may come in, just because they're dealing with slightly larger numbers of pupils, numbers of staff, etc. But legitimate interest usually refers to marketing activity. So you could say it's in the legitimate interest of a very large school or a very large group of schools, such as a multi-academy trust, to have a look at the local electoral register and to directly canvass people on the basis that they may have children who could actually apply for admission to their school or schools at some stage in the future. But legitimate interest is exactly the idea that I was talking to you earlier on. It is possible for organisations to look at your activity online, and if you've just bought airline tickets to Singapore, for example, you could be bombarded with offers of very good hotel accommodation. Now, that's a legitimate interest. These are people who are target marketing specific individuals, and as long as it's done properly, as long as it's done with in compliance with GDPR, no problems there. But as I say, again, relatively unusual in the school setting. Question just come in there from Michael about retention of data. GDPR doesn't say much about the timescales, it has to be said, Michael, in answer to your questions. I think what I would say there is most schools maintained schools in most local authorities, most borough council areas, use something called the Information Records Management Society guidance, and not something as governors we need to get hugely into, but certainly it's more of an issue for clerks to governing bodies, clerks to trust boards, I would suggest. But for most, it will normally be current year +3 or current year +6, as in six years or 3 years. But of course, governing body minutes, as I say, they have to be retained forever. Now, you need to think about how you do that. But of course, this is one area, retention, where lots of schools perhaps have not been that meticulous about their curation, shall I say, and how they curate those records, because there does need to be a regular review, and that data map and flow ought to have on it how long you keep that information. So I hope that answers your question. Jazz has just put a question on about alumni. Alumni, I would know, you could say it's legitimate interest. Yes, that is a marketing one. You can contact them through legitimate interest. You can't keep their information on your website, I would suggest, without possibly seeking their permission. I mean, that's not a straightforward one. That's something I think you'd need to look at the specific guidance from the ICO on and decide which one fitted best. But certainly you'd want to look into that in a little bit of detail. Another issue there on sending message out, parent mail, can it be used to send messages on behalf of the PTA? I think that's an interesting one. Again, I think it's something that schools would need to be very careful about how they've actually told parents they're going to do that. For me, that is a marketing one, so you could say it's legitimate interest, although just for safety's sake, you might want to say, well, we'll add that when we send the thing out about parent mail, we'll get consent for that at the same time. Newsletters, any other communication coming out of schools, you would expect schools to do that, and that is part of the ongoing communication. Schools are legally obliged to communicate regularly with their parents, so that one comes under legal obligation, doesn't come under anything else, I would suggest. Okay. Quick word on privacy notices there. Forgive me, all I've done is just on a quick screen print here of something I found on the ICO, the Information Commissioner's website. I like short and simple, and this does it for me. A good privacy notice or privacy notice should tell you who it is who's collecting your data or your information, what they're doing with it, in other words, how it's going to be used, and if it's shared with somebody else. And it's as simple as that. Now, there are some guidance documents on the DFE website, also available through the ICO, in terms of model privacy policies. You do need to work on them. You need to actually make sure they're appropriate for your schools, but they are there as a start, as a starting basis for you. A couple of days ago, linked to that, the DFE produced something called Data Protection, a Toolkit for Schools. I've put the links to all of these items I'm referring to on the penultimate slide, I think it is, so you can download those at your leisure. It's a fairly weighty tome. It's 70-odd pages in total, but it's well worth a look at, this data protection toolkit on for schools. That gives you a lot of information on most of the areas I'm talking about this morning. Question here from Gilly: do we need to obtain consent from pupils to share their test results? Sorry, forgive me, I need to click on your questions to be able to read all of it. Test results, behavioural issues, reports, etc. with their parents. There is a requirement for reporting to parents. That's covered by an Act of Parliament. However, the one thing you do need to be careful of is that the age of consent is 13. So if you're a governor in a secondary school, you need to think about where consent is the basis. And consent, you do not need pupils' consent to share their test results as part of the overall test results. If you want to make a big thing, so your star pupil who's got a place at a leading university or whatever, or has got onto an apprenticeship scheme or anything that is worthy of celebrating, yes, you would need their permission to use that as part of a press release, etc., to promote the school. But no, in terms of the aggregated results of all pupils, if you're sharing behavioural issues, etc., anything you are required to share with parents under the legal obligation, does not fall into that. But be aware that if you want to use data for pupils, and I don't just mean performance data, but any information we hold, you will have to give parents information on that, but you would need to seek pupil permission if they're over the age of 13. Yes, Gilly's just put something on here, children going into detention. Yeah, that's a statutory duty. There's a safeguarding element of that, of course, as well. No, parents do not need to actually sign up to privacy notices when their children enter school. You only need a privacy notice where you are talking to parents. I mean, it may be worth having one on the school website, but parents don't have to sign it necessarily. It's worth thinking about telling parents about the data that you hold, but certainly most schools would have a privacy notice that says this is the information we will be wanting to collect. So it's a pertinent time of year to be thinking about this now, because our schools with new entrants coming up will be asking for lots of information. Okay. Right, let's just go back to the slide. So next one, I've got a data protection officer. This is something that's causing quite a lot of consternation in schools at the moment. Come back to that in just a moment. The data protection officer, and again, there's a lot of information. I've referenced in the further information slide at the end, the General Data Protection Regulation Handbook from the Information Commissioner's Office. There's a lot of information in there. It's well worth having a look at. There is also some that comes in the DFE toolkit on page 37 of that toolkit, which is also worth having a look at. But in short, this is somebody, it has to be a designated individual who's responsible for compliance. In order to be responsible, they have to be knowledgeable about compliance. They have to be able to support colleagues. That may be about raising awareness, it may be about training, but to support colleagues and the relevant authority. And of course, the relevant authority is the Information Commissioner's Office, in order to actually carry out that role. One of the other requirements is that they have to report to the highest level of the school stroke trust leadership. And of course, what that means is this isn't a role that you can actually give to somebody who does not have regular contact with head teachers, CEOs, etc., because this person is instrumental to the security and the compliance of the organization. One of the things we have to be careful of is that we avoid conflicts of interest here. So the one thing that you can't do if you're a large school or a trust and you've got your own IT manager or data manager, etc., if that person is responsible for collecting the data, for commissioning data to come in, they cannot be the data protection officer, because that's a sort of, you know, poacher and gamekeeper together. So what we have to do is ensure that we don't have that conflict of interest. So the guidance specifically says the head teacher and the ICT manager cannot be the data protection officer. Now, some school business managers can do that role. Importantly, the role has to be independent of the data side of the school's work. So that's something to think about, and something I think governing bodies have to have some very real discussions on. Lots of people have said, oh, well, of course it can be a governor. Yes, it can be a governor. The phrase caveat emptor springs to mind, yeah, but buyer beware here. As a governor, personally, and this is a personal opinion, I would not do this. There is a huge amount of accountability linked to the role of the data protection officer, and that's not something that I would want to take on as the governor, because I'm not operationally involved in the school, quite rightly, to the level that I would need to be in order to actually do that. So Janice has just said, could you please repeat the point about independence? Yes, the data protection guidance, so both the DFE publication and the Information Commissioner's Office, says that the DPO, for Data Protection Officer, must be independent. Now, that doesn't mean independent of the school, but it means independent of the collection and the control of that data that's coming into school. So if your school business manager also happens to be the person that is responsible for maintaining the SIMS, is a system that most governors will be familiar with. It's a capita system that is used for data in lots of schools. Some trusts may not be using it now, but hopefully you'll know what we mean by that. If you're the person responsible for commissioning that, for buying that, for actually maintaining that system, you are involved, therefore you are not independent. Basic question, what does ICT stand for? Sorry, Information Control Technology. I should have said IT probably rather than ICT, shouldn't I? I do apologise, but most schools still call them the ICT manager. It means IT, it's the computing bit of the school. Apologies for that. No, the DPOs, they cannot be the head, possibly shouldn't be a governor, but you can actually share the role amongst schools. So several schools can say, well, okay, the named person is this person. They just happen to be the named person over a number of other schools as well. And that's perfectly acceptable. There are companies out there providing services. Again, be careful and advise your schools to be careful. Some governors actually at a face-to-face session I was delivering the week before last were saying their school was actually paying £11,000 a year for this service. I'm not convinced it's a service that's worth paying £11,000 a year for. Certainly my advice would be in the first year, it's worth keeping a very close eye on what does the role actually include. You can't give over the responsibility for doing the audit to somebody else because they don't know what data your school has. So somebody in the school has to put the audit together. Then it's a question of maintaining that data flow, thinking about all of the other implications that we've talked about this morning, and ensuring that the information is kept up to date and safe, so that were there to be a breach, you would have someone who would actually have their hand, really on the pulse of sort of what's happening as far as data is concerned. They're knowledgeable about what happens in your school, and they are able to respond appropriately if there is a request for information, if there were a serious breach and the ICO wanted to talk to the school, etc. So from a governor's point of view, just think about the amount of time that you might have available to do that, because that should influence us as well. But again, something to be thinking about, but not something that I would necessarily say is something that's on everyone's agenda right now. I see we've got a question here from Catherine. Hi, I'm a governor in a very small school, and so we're struggling to find someone willing to do the role. I'm facing lots of pressure to be the DPO and don't feel comfortable to agree as I'm not operationally close enough. Who can we suggest does the internal audit within the school, at least as a starting point? Well, unfortunately, Catherine, yeah, all small schools, somebody has got to do it. And actually, the reality is, even if you said, okay, we're going to pay somebody to come in and do the audit, which is, you're right, that is the start point, the audit can only be done by the head teacher and the school business manager or bursar or whoever it is, and everybody else sitting down and thinking, okay, what information do I hold that fits the bill of personal, because teachers will have personal information. The school office will have personal information, the school business manager will have personal, so will the head teacher. All of those people need to participate in that audit. So I don't think that's something that any school of any size can actually walk away from. There has to be, a whole school approach to this. There's got to be an awareness raising, but there's also got to be an involvement of everybody in the way in which that data is actually collected. Would I recommend that we have a GDPR link governor? Maybe on an ongoing basis, that might be something to think about. I'm not in favour of posts like that, if I'm really honest. I mean, I think at this point in time, it is sufficiently top of mind for all of us that I would suggest it comes at least to the full governing body initially. You can then actually, if you have a committee structure in your school, say no, on an ongoing basis, this will be something that's handled through a resources committee or whatever. But this is a governing body responsibility. The whole governing body needs to ensure that the school's compliant, but I don't think on an ongoing basis it's something that I would really want to allocate a role for. My view is about governors with allocated roles now, they ought to be linked more to priorities and school improvement rather to things as operational as hopefully this will become in time. That doesn't mean, of course, that from a compliance perspective, we don't avoid making sure that this does regularly come up on governing body agendas, so that governors are seeking that assurance that schools are still complying with their requirements. Okay. Let's move on. I've got another poll that I'd like to launch now, if I may. And this is a real simple one. Just want to ask the question: has your school actually appointed a data protection officer yet? And hopefully the poll should be up on your screens now. So if you can vote, thank you very much. Lots of people have already. Just while you're finishing to vote this, Catherine's asked a question: can schools work out data protection officer reciprocal arrangements? Yes, Catherine, they absolutely can, and lots of schools are doing that, either through local collaborations, or say in a multi-academy trust you would probably make arrangements to do that with at least most of the schools in the trust, if not all of them, but that would depend on geography. Preeti is asking a question: are there any statutory returns that need to be filed on a periodic basis to the ICO? As far as I'm aware, the answer to that question is no, but there is an obligation. If you have a breach of data in your school, then you have 72 hours to report that. So that's the only statutory reporting that I'm aware of at this point in time. But as I say, I may be wrong on that. I hope I'm not, but that's my understanding at this point in time. Okay, I think most people have actually voted now, so I'm going to close the poll and share those results with you. And as you can see, just over a third of people say yes, they know that a data protection officer has actually been appointed. 70% know, and 47% don't know. So that's nearly half who don't actually know. So it's a really good question to go back and ask, because again, this is all about compliance. The law says by the 25th of May, we ought to actually have a name in the frame on that. So certainly something worth thinking about there, I would suggest. Okay, wanted to say just before we finish this morning, there is a right to be forgotten. It's a limited right, it has to be said, and there's certain information that is linked in terms of time frame, etc. But any personal data, if you don't want somebody, so you might be getting emails, etc. now promoting products, services, etc. coming through to your personal emails or perhaps business emails, at the bottom there is a legal requirement that if you no longer wish to receive emails, click this link, etc. That's all about the right to be forgotten. Some areas of personal data, absolutely, we have to think about in schools. When will we actually get rid of that data? How will we securely remove it from our systems, etc. Other data, so for example, safeguarding information about pupils, there are statutory limits on that. Pupils with special educational needs and disabilities, that data has to be retained for the period up to the person's 25th birthday. Governing body records, as I say, are permanent, therefore they can never disappear. But all of that is up for discussion, and you need to think in your individual settings what your retention of various documents is, and say talk to your clerk, talk to your school business manager about that. But make sure that for all of the data that you have, somebody is looking at it from time to time. Good example here, one of the other aspects of the work that I do is conducting safeguarding audits in school. And as part of the safeguarding audit, I always ask, can I have a look from a safer recruitment perspective at some of your HR files? And very often you'll pick an HR file at random out of the drawer that's hopefully locked, and you'll see in it there's a hard copy of the DBS certificate, there's a photocopy of a passport, there is a photocopy of someone's birth certificate, and other personal information. Now, even under current regulations, forget about GDPR, but actually you only can hold information whilst you are using it, and the only use you have for that identity information is to get a person's DBS check, the Disclosure and Barring Service check. So the moment you've seen that information that proves their identity, you should destroy it because you no longer need it. The record of that is your single central record, and that should have an initial and a date when it was seen. You do not have to keep that information. So that's just an example, but there will be lots of pieces of information like that. Application forms for teachers or other members of staff that come to our schools and didn't get the job. You would need someone's consent to keep that on file. Should a vacancy come up again, could we contact you? Otherwise, you have to respect the fact that that individual has the right to be forgotten. Okay, and my penultimate slide, this is just coming to them. This is just a little bit of a summary, really pulling the threads together. For me, that phrase, shall we say, I would say buzzword, it's 4 words, so it can't be buzzword, but that phrase, what we do as governors is we ensure through seeking assurance. I use that a lot of time in lots of different areas of governor development, governor training, but the seeking assurance for us here, part of that means that we do have to understand the key changes from existing data protection legislation to GDPR. We need to make sure that we are on the road to compliance by the 25th. So, yeah, those of you that maybe didn't know at this stage whether you've got a data protection officer, go back in school and ask that. And if the answer is no, what are we doing about it? We've got to move quickly. We need to think about policies and procedures in school about retention. We need to think about policies and procedures about collection. So as governors, have they been reviewed? We need to actually make sure they are. I've said scrutinise the appointment. When I say scrutinise, I mean look at it in detail, because you could end up getting very poor value for money in terms of jumping in on this one. So think about what arrangements we're putting in place for DPO. Can we afford them? Is it the right level for us? Do we need this particular form of cover? Because lots of schools are spending significant amounts of money. This is not being funded by central government. This is coming out of our budget. So I think we have to think long and hard about this. What say do governors have in choosing a DPO? Janice has asked the question. I would suggest you do have a say. I think you're perfectly entitled to ask questions, and I think one of the things that governors are responsible for is value for money. Governors are also responsible for agreeing the staffing structure. If the school is going to create a new post, my view is they need governors' permission to do that. Now, governors don't have to be involved on the interview panel and don't have the final say as to, oh no, we wanted somebody with red hair rather than black hair, that kind of thing. But agreeing to the size, scope, scale of the post, I think absolutely is a governing body responsibility. Most important of all, of course, think about how as governors we're going to monitor compliance on an ongoing basis with GDPR. And again, if you're in a local governing body, go back, ask the trust, well, what's the trust doing, and how does that impact on my role as a member of a local governing body, local committee, etc., in the school where I'm actually serving at the moment. And that just about brings me to all I would like to say. There's a message about better governor at the end there, so please, if you're not already registered, check it out, have a look at it. We regularly post on there, and we offer lots of services information to governors or anybody involved in governance, including clerks, on an ongoing basis. And my last slide there, as I promised, is all of the further information. So anything I've referred to in the webinar this morning, you've got the URLs there. I'm sorry, the last one is a very long one, but whatever your search engine, if you want to just search for DFE toolkit on data protection, you'll find it, and similarly the videos, etc., from the DFE, all of those are easy to find if you just put in the search engine. One last question here. I think we've got Diran has actually asked a question: are there cost-effective data protection services that you can recommend? Sadly, no, there aren't. And again, I don't think anybody knows whether they're cost effective or not, because cost effectiveness you can only judge after time. This is new. I mean, the other thing I didn't say, but I make a point of saying to governors, nobody is an expert on GDPR yet. They can't, because it hasn't started. There's lots of people think they know a lot about it, but my recommendation on everything to do with GDPR is shop around, use as many sources as you can. I have been to lots of different conferences, webinars on this myself. I've done a lot of reading up. I wouldn't dream of calling myself an expert. I'm somebody who has taken an interest in it professionally, because that's my job to do so, and I know a little bit about it. I'm not an expert, so it would be entirely wrong for me to recommend anybody to you. Do governors have to have school email addresses? No, they don't at all. Lots of people are going around saying that that's a GDPR recommendation. That's a bit daft to say that, to be perfectly honest, in my view, because I do have, I think I've got 7 email addresses. I'm the governor for my sins in 4 different establishments at the moment, and 2 of them do have governor email addresses. Now, I reroute them all to my mobile phone, because that's the way I do it. I'm actually a very busy person, as I'm sure most of you are. Now, I am very, I'm very good, I think, about security, but other people aren't. And it doesn't matter what your email address is. If you've got a shared computer at home, who has access to it? It's about individual security. Having a bespoke email address that links you to a school doesn't make it at all secure. It's what you do with it guarantees its security. So I think from a governance point of view, just make sure that, as governors, when there are, pieces of information that could potentially contain the sensitive personal data or any personal data, what's my own security like? How do I treat my own records on my computer, etc.? How do I make sure that I'm actually protecting them? But I think there is a wider rule, and something that we actually share with all of our clients is governors generally should not have personal data. Personal data shouldn't be shared with governor. So as a rule of thumb, any documentation for a governing body meeting should not mention anybody by name, unless it's praising or sharing. And then I think we need to be a little bit circumspect about it. But circumspection is important in any kind of communication for governors. So I would certainly be mindful of that. The only exception to that would be things like disciplinary panels, that kind of thing. But even then, I would say to clerks, do not send information electronically. Have hard copies that you have that you personally deliver to people. Collect them in at the end, and then shred them, because there is incredibly sensitive data there. There will be certainly special data in a lot of those instances, and it should not get into the public domain. That would constitute a major breach. So, but getting governors to think about their own security of electronic communication is actually quite a sensible route, and that's something we should all be doing, I would suggest. Okay, well, I don't see any more questions coming in, folks, and we've run a few minutes over, so apologies for that, but hopefully that's not a reflection of me talking too much. It's a reflection of the number of questions we've had. I hope I've actually managed to answer all of the areas of the question. If I haven't mentioned your question specifically, apologies, but hopefully I have actually covered it in addressing the general questions that have come in. Thank you very much for joining the webinar this morning, and look forward to hopefully welcoming you again in the future. As I say, if you want to look at the handout and download it, you can actually still do that now. I won't turn the webinar off for probably about 5-10 minutes or so, so you've got opportunity to do that. Thank you very much for joining us, and enjoy the rest of your day. Thank you.